if everybody's here, I will call to order the October 31st Subdivision and Development Appeal Board hearing to hear the appeal by the applicant, to hear an appeal by the appellant of a decision by the Development Authority to refuse development permit PL 20250199 for visitor accommodation 27 units and employee housing 1 unit 99 Three Sisters Drive. I'm Andre Gianandrea. I'll be the chair for the hearing. All questions and comments shall be directed through me. At this time, I will ask my fellow board members to introduce themselves, starting to the right.
Councillor Tanya Fobert.
Michelle Coos, public member.
John McClure, public member.
Thank you. We are to understand there's a preliminary matter that would need to be addressed. If that is the case, would the applicant please step forward, introduce themselves, and speak to your preliminary matter?
Okay, I will start again. Good morning, Mr. Chair, board members. My name is Rick Grohl. I'm the agent for the applicant as well as the developer and property owner. We are respectfully requesting an adjournment until November 14 to allow my team to respond appropriately to the 310-page submission that was submitted by the legal counsel for the appellant, which we received on Tuesday afternoon. This is a complicated development site, and also some new arguments are being made in the appellant's submission, which we like to appropriately address with our team, which also can significantly reduce the efficiency and of the merit hearing. And we believe there's no prejudice to the appellant's team to grant an adjournment of 2 weeks because they had their adjournment granted. Equally, we believe it would be appropriate for the board to consider my team appropriate time to respond to the submissions made. As I've stated in the previous hearing, I'm typically booked up in Calgary on Tuesdays and Thursdays until Christmas. Every Tuesday and Thursday I'm already booked, and therefore I request that the matter would be heard on November 14. Thank you very much.
Thank you. Does any member of the board does the board have any questions for the applicant?
Mr. Chair. I missed your name, sir.
Rick Grohl.
Rick Roll, Mr. Roll. Did you have time to review the package since receipt on Tuesday?
We did have time to review it myself, but I need further time to peruse some details with my applicant's team.
Okay, thank you.
Does administration have any objection to the? Oh, pardon me.
One question. Do you anticipate submitting any further?
We will, yes, it's the intention of us to make a written submission in response so that you have within a week of the normal deadline for submission to have appropriate time to review our submission and our response to all the grounds that were raised by the legal counsel for the appellant in their extensive written submission. Thank you.
Anything further from the board members? Anything from administration?
Chairman, no objection to the request.
Thank you. Does the appellant have any objection?
Good morning, members of the board. My name and chairperson and otherwise those in attendance today. My name is Bonnie Anderson. I'm legal counsel for the appellant, which is Worldmark The Club, Inc., and it's known as Worldmark Canmore Banff. Worldmark owns and operates a visitor accommodation building or business immediately adjacent to the proposed development. And we are in opposition to the request for an adjournment today for a number of reasons, and I'll articulate those. Worldmark shares about 200 meters of shared property line with the appellant land, so it's a very tight relationship, I would say, and important to get it right. However, again, I will articulate reasons why we oppose the adjournment. I have Gavin McCaffrey here today. He's the general manager of Worldmark here in Canmore. And I also have Gord Miner. He's the VP Resort Operations, who's not here today, but he will be watching by video and available should we need to make any decisions in his absence. He couldn't be available today. For those of you, I don't think we had 5 before. So did we have 5 or did we have 3 the last time we were before you? Just out of curiosity, did we have 3? 4? I'm just thinking of new people. So for those who didn't know the adjournment request before, I think that's important to go through as well. So the first adjournment request, yes. Yeah.
Is that, just procedurally, is that something we need to re-read?
Oh, you don't need to re-review. I was just wondering if others knew why that was requested, because it seems to be intimated today that it's a similar type of request, and I would arguably say it's not a similar type of request in terms of what we had before us at that time.
Okay.
So, okay. So I'm just going to continue on. We understand we have another adjournment request before the board today, and asked that it be dealt with as a preliminary matter. Again, we have instructions to pose the adjournment request. The adjournment request appears to be based upon the fact that I submitted a 310-page written submission on Tuesday's deadline. I can advise as to why that would have come in at that point in time. For those of you who weren't at the last meeting, is I just received miscellaneous documents last Wednesday that I've been asking for from the applicant and or the development authority for 2 months almost. And so I received a stack. By the time my assistant printed it, it was a stack of 6 binders of materials last Wednesday. I had 3 business days to put together my submission. I also did not know what of those materials would make their way into the STAB report. So I spent the entire weekend going through everything. And so it's a different situation than what Mr. Grohl has suggested in terms of why it's come perhaps at a later time and why he must need additional time as well. Most of that stack of documents is literally this tall. It's a lot of duplicates, et cetera. We printed it all. Was completely available to the development authority and the applicant in advance. We were the only ones as the appellant who didn't have a lot of that information. So we just got that last week. So you have a 310-page document before you. But I will say that I'm going to go through it, but almost all of that document, save about 50 pages, is all materials that have been before this board and or in the hands of the applicant or in the hands of the development authority for months, if not maybe a year. It was the first time we saw a lot of documents, but it's not the first time they did. So I think that's important to understand. Now, the MGA provides that appeals are addressed in an expeditious manner. Now, it might seem like the developer is always being imposed upon by getting extensions, so we shouldn't have extensions. In our case, we would like this heard as soon as possible. And the case law indicates that where you're looking at adjournment requests, a reasonable, diligent party would have been able to prepare. In our view, of the 310 pages, there's about 50 new pages. And we believe that because a lot of that material that we got last Wednesday and the material within the report that we submitted is not new. It's not new. It's about 8 pages of our submission is new because the zoning item is already known by the appellants and the Development Authority. So even our submission, our written submission, which is 14 pages, 8 pages of it is maybe new. And so we're just gonna go, let's see. I'm gonna go through the submission. If it's 310 pages, we're gonna talk about what of that's actually new. So pages, oh, sorry.
So I just want to make sure we are in a preliminary situation.
I'm not gonna talk about the content or arguments.
Okay.
No, sorry if I suggested that. The suggestion is that this is all new. It's impossible to review. We need another adjournment. But what I will say is that of my submission, which is 14 pages, 1 to 6 is a zoning question that everybody knew. Because in looking at the binders that I looked at, they've known about the zoning issue for months and months. Pages 8 to 14, so that's 6 pages, is new stuff. But it also is just prior development permits for the property. It's not a whole bunch of new stuff that we came up with. With respect to the tab documents, which makes up the bulk of the 290 other pages, we've got a new 2-page letter from our client. We've got a new 1-page letter from Grand Canadian, who's next door. Tabs 1 and 3 contain land use bylaw excerpts in the MGA, which the other parties already have. Tabs 4 to 7 contain land title plans that they already have. Tabs 8 and 9 contain city view reports, which are from the town, available online. Tab 10 is previous town zoning letters, which are arguably something we were able to obtain. That might be considered new. That's just a few pages. Then we've got tab 11 is the DA development permit review. That's actually generated by the town, part of the record already. Tab 12 is the development permit site plans, already in the record. I just attach, sometimes I attach things to my submission so that you have them handy together. And so a lot of this stuff is not new. Tabs 15 to 17 of my submission are the original development permit for the site and development agreements. Both of those are either available through the town records or available through Land Title's office. I did not come up with these documents. And the development agreements are registered against title, so they could be found. And tabs 18 to 22, they're possibly new, but it explains the 187 parking stall issue. And I'll get to the end right now. The last 3 documents in my submission are the 3 easements. Again, they're already in the town record. One of the challenges with appearing before the board and having written submissions due before we get the record sometimes is I have no idea what's going to be in the record, so I will, you know those binders that we got? They're not all in the record. So I have no idea what's going to actually be in the published record at the end of the day. So there's a bunch of administrative stuff here where the 310 pages are somewhat the result of where this material gets posted and where it gets put into the public record. So at the end of the day, there may be about 55 pages of new materials. 8 of the written argument and about maybe 35, 40 new pages. It sounds like we've got this huge amount of information that's come forward. It's crazy to review. We just are of the position that that's just not the case. Now, we do know that it seems reasonable. We don't want to have the applicant complain at the end of the day that they didn't get a fair hearing. So if this board does see fit to grant the adjournment, we would ask that the written submission, like I had 3 days, we would ask that the written submission be put in by Monday or Tuesday of next week, and that the hearing be on the 7th or close to that time. And we just have one other submission for this board to consider in terms of timeliness, and I'll give Mr. Grohl a copy. And if you need a copy for the boards, they're still in there. You're going to receive a photograph that was some very quick steps that the applicant took without getting a proper permit. And I'm not making arguments that are related to our submissions. I'm indicating why it's important to get this moving. Is this ended up being cut away, et cetera, without even a permit. They had to issue a stop order. So the only importance of this is to say, we also want this rectified right away. One of our accesses are cut off, parking stalls are now cut off, and we just want this resolved. So it's not just the developer from a financial perspective that wants this resolved, we actually want this resolved ASAP. And this is, again, a second request for an adjournment. So if there is a decision coming out of this board that an adjournment is appropriate, we would appreciate if we could get this done next week. They don't need 2 weeks to figure out what these materials say. We actually had to do a lot of catching up. I've been asking for materials since September, even August, to get the development permit file, or the development permit plans, the development permit conditions of approval. I finally get this package on October 22nd with a ton of material in it. So if I can put together our arguments by Tuesday, then I would ask that if there are any further submissions, either on my part or on the appellant's or the applicant's part, I would ask that they be due on Tuesday of next week at the latest, and then have the hearing on the Tuesday at 9 o'clock, and then have the hearing on the Friday. We shouldn't have to go into the following week. This is a lot of material that's already known. The material we got on Wednesday, we did not have a chance. There's stormwater reports, et cetera, within the material on Wednesday that we received. We do have somebody on transportation to look at some items, but there are a couple reports that if there are further comments we need to make, we would appreciate. It's not going to be 310 pages long. It might be just a letter or so from our expert, but we would appreciate if they're having extra time just to have a couple extra days for us as well. But Tuesday at 9 o'clock is what we're suggesting. We would also ask that any hearing date be scheduled on a peremptory basis. And what that means is we can't ask for any further adjournments. It's just get this done, get the board record online, and then have the submissions due, and then have the hearing. Those would be, and last but not least, while I do appreciate Mr. Grohl's schedule, not being available Tuesdays and Thursdays, we've all got very, very busy schedules. So the fact that somebody is away every Tuesday and Thursday is not, to me, something that the board has to take into account. If there are other people, there were 9 people on a call the other day, which we appreciate having with the applicant. Surely every Tuesday and Thursday should not be cut out from every week, so that we continue to delay into the 14th and whatever other dates. Those are our submissions and our concerns. Thank you.
Thank you. Any questions from the board? Thank you.
The picture that you circulated, what What are we supposed to be looking at? What's the,
Sure, that's actually what took place next door. So what we're indicating with the picture, and the only reason I've showed you it, it's not to be alarming or anything. What it is to show that steps are being taken quickly. We weren't advised or given much notice that that was occurring. That occurs, and town had to issue a stop order because there was no development agreement. All we're saying is, things are moving quickly. We understand the developer wants to move quickly as well. We just want things resolved so that things like that next door happen with the proper permits, we don't have to get in stop order issues. We don't even have to have the conversation with them. Let's just get this permit addressed and dealt with appropriately so we don't have to have that occurring where access and parking stalls, et cetera, are taken out of operation. That's the only point of that. It's not like, oh my God, they're clear cutting. That's not the emphasis. It could have been any landscaping. It may look bad, but it was just a picture that I had of what had gone on next door without proper permits.
Any further questions from the board? Thank you. If I could get a motion to go into recess so we could discuss the adjournment.
Motion to go into closed session?
Okay. Sorry. The board will stand in recess for the time being.